Welcome to the Vocational Views channel. Today we are going to discuss what can be a human resource nightmare. In today's video, I want to walk you through how workers' compensation, the Family and Medical Leave Act, and the Americans with Disabilities Act actually fit together in the real world, not in a textbook, but in the cases you're handling that can become stressful. Attorneys, HR professionals, risk managers, and adjusters often tell us the same thing. We understand each law in isolation, but we're not always sure which framework applies at which point in time, or how to coordinate them without stepping on a landmine. From a vocational expert's point of view, these laws are three different lenses on the same person's work capacity and job relationship. Workers' comp focuses on the injury and benefits. FMLA focuses on job-protected leave, and the ADA focuses on accommodation and essential functions. In the next few minutes, I'll give you a simple, practical map you can use in your own cases, and I'll also show you where vocational evidence can support your decisions. Let's start with the big picture. Workers' compensation is usually where things begin, because that's where the injury or occupational disease shows up. Workers' compensation is about the injury and the benefits that flow from it: medical care, wage replacement, sometimes vocational rehabilitation. The core questions are, was this work-related, and what benefits are owed under the statute? But workers' comp by itself does not answer the question, can this person still perform their regular job, and if so, under what conditions? It may touch on temporary restrictions or permanent impairments, but workers' compensation is not the full employment law picture. FMLA is very different. FMLA is about job-protected leave, not workplace changes. The key question under FMLA is, can this person be off work for a defined period and still have their job protected? It doesn't require the employer to modify duties or create new positions. It allows the employee to step away from work without losing their position, at least for the duration of the FMLA entitlement. Then we have the ADA. The ADA is essentially the accommodation framework. It focuses on whether the employee is a qualified individual with a disability, meaning they can perform the essential functions of the job with or without reasonable accommodation. Here, the core question shifts from are they off work to what adjustments, if any, would allow them to do the job. Finally, the vocational expert sits at the intersection of all three. My role is to connect medical restrictions and functional limitations to actual job demands, labor market realities, and work options. I translate what is on paper into what that person can reliably do in a real workplace, over a real workday, at a real level of productivity. It helps to think of a typical case as a timeline. It starts with an injury or a health condition that affects an employee's ability to work. Maybe a worker lifts something, develops back pain, and files a workers' compensation claim. At the beginning, workers' compensation is driving the process: injury investigation, initial treatment, usually medical and medical case management, and temporary work restrictions. At some point, the employee may be unable to work full-time or even part-time for a period of time. That's where FMLA can come into play. FMLA asks, is this an eligible employee with a serious health condition who needs time away from work, and can we protect their job while they're out? The focus is on leave, not on modifying the job itself. Now, what often happens is this: the FMLA clock runs, and the worker is not fully recovered, or they come back with permanent or long-term restrictions. Or perhaps the injury was never even filed as workers' compensation, but we still have real functional limitations. That's when the ADA framework should be front of mind. Under the ADA, the question becomes, given these restrictions, can the person perform the essential functions of their position with or without accommodation? If not, are there other vacant positions they are qualified for? That calls for an interactive process and sometimes multiple touch points as the medical picture evolves. Over the life of a case, you may move from workers' compensation to FMLA to ADA and sometimes back and forth as conditions change. The laws are not in conflict, but they are answering different questions at different moments. Workers' compensation. What benefits are owed for a work-related injury? FMLA. Is the person entitled to job-protected leave? ADA. What accommodations, if any, are required for a qualified individual with a disability? Having one coherent map keeps you from relying on the wrong framework at the wrong time, and it also helps you explain your decisions to opposing counsel, to the court, and to the employee. So where does a vocational expert fit into all of this? The ADA hinges on the concept of a qualified individual with a disability, someone who can perform the essential functions of the job with or without reasonable accommodation. To evaluate that properly, you need two things: a clear understanding of what the job actually requires and a clear picture of what the employee can and cannot do in functional terms. That is where vocational analysis is extremely useful. First, I conduct or refine an essential function job analysis. We look not just at the written job description, but at what the job really demands: physical requirements, cognitive load, productivity expectations, pace, and environmental factors. We separate essential functions from marginal tasks because that distinction is key in ADA cases. Second, I take the medical restrictions, lifting limits, standing tolerances, concentration issues, need for breaks, and so on, and translate them into work capacities. What does no prolonged standing mean in terms of an 8-hour workday? How does a restriction on overhead reaching affect the essential functions? Those answers are not always obvious without vocational expertise. Third, I help identify realistic accommodations and alternatives. Can the person continue in the same position with modifications? Are there other vacant roles in the organization that match their background and restrictions? What impact would proposed accommodations have on productivity, safety, and coworkers? Finally, I provide structured documentation that supports legal decision-making. That might mean reports, testimony, or consultation that explains in plain language why a particular job is or is not within the worker's capacity, and whether suggested accommodations are reasonable or would cross into undue hardship. When workers' compensation, FMLA, and ADA questions are swirling around the same worker, vocational evidence can be the piece that ties everything into a coherent story. Here is what happened medically. Here is what the job requires. Here is what the person can do now. And here are the realistic options on the table. Let me pull this together. In any case where injury and work capacity are at issue, workers' compensation, FMLA, and the ADA are often all part of the landscape, but they are not interchangeable. Workers' compensation addresses the injury and the benefits owed under statute. FMLA addresses job-protected leave for serious health conditions. The ADA addresses reasonable accommodation for a qualified individual with a disability, focusing on essential functions, and the interactive process. Overlaying all of that is the question of what the person can realistically do at work over time in a specific role. That is where vocational analysis adds value, clarifying essential functions, translating medical limitations into work capacity, and helping you document defensible decisions about leave, return to work, and accommodation. If you handle workers' comp, ADA, or FMLA matters, and you want a clearer way to integrate vocational evidence into your strategy, this channel is built for you. If you found this helpful, please subscribe to Vocational Views and feel free to reach out if you need support on a specific case. Thank you for watching.